Good afternoon. This is the matter of SPT, SP, SM, AM, and RM. We have Assistant Prosecuting Attorney Laura Clifton, Mother Danielle Marsh. We have our attorney, Kristen Newhouse. We have Father Scott Parks, Mr. Parks's attorney, Audra McClure, Father Timothy Marsh, Mr. Marsh's attorney, Kendra Ortega, the children's attorney, Deborah Coletti, various agency workers, and a foster parent. We're here today for an adjudication in this matter, and it's my understanding that the parties have reached a plea agreement. Is that correct?
That is correct, Your Honor.
Correct.
Right.
Guys, today we're stepping into a tense courtroom where emotions run deep and every word carries weight.
And for the record, Ms. Clifton, would you place the amendments that the parties have agreed to on the record?
Sure. Paragraph C will be removed in its entirety. In paragraph G, the phrase "in January of 2022, a cat won for sexual abuse by Miss Marsh's boyfriend" is going to be eliminated. Paragraph L will be amended to read, "On 5/15/2025, Miss Starlet Schrader stated that Danielle Marsh called her from jail and asked her to flush her drugs located in her nightstand." Paragraphs M and N will be omitted. On paragraph O, we're going to add this last sentence. Miss Marsh pled to domestic violence on 8/27/2025. Removing the paragraphs Q, R, and S. In paragraph U, we're going to change the
I'm
words.
sorry to interrupt you, but you skipped P.
P?
P is going to remain the way it is originally,
Yes.
right? Okay, sorry,
Yeah.
Go ahead.
Paragraph U, we're going to replace the words where it says parole with the words probation and remove the last sentence. Paragraphs V, W, and X will be eliminated, and we'll insert a new V, which will say Miss Marsh participated in prevention services, however, would not sign a release of information to allow CPS to verify participation. Taking out the paragraph Y. In paragraph Z, again, replacing the word parole with probation. Paragraph AA will be replaced with the phrase, "Mr. Marsh is unable to provide proper housing at this time." And that's the remainder of the amendments. The rest will stay in.
All right. Any corrections to what Ms. Clifton has placed on the record regarding the amended order or
No,
amended petition?
No, Your Honor.
No, Your Honor. All right, thank you. And are the parties willing to waive the initial reading of the amended petition?
Yes.
Your Honor.
Yes, Your Honor.
All right. Mr. Marsh and Ms. Marsh, would you raise your right hands, please?
Yes.
Okay, I need to see you.
Sorry, hold on. I'm trying to figure it out.
There we go. All right. And Ms. Marsh, would you state your full name and spell it for the record?
Danielle LaQuelle Marsh, DANIELLE, LAQUELL, and then MARESCH.
Right. And Mr. Marsh, would you state your name and spell it for the record?
It's Timothy Allen Marsh Jr., TIMOTHYALLEN MARESCH GUNIOR.
All right. And do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, I do.
All right, thank you. And do any of these children, are any of these children eligible for a Native American band or tribe membership?
No, ma'am.
No.
Okay. And Ms. Coletti, do you believe that the proposed pleas are in the best interest of these children?
Yes, I do.
Right. And Mr. Marsh, do you understand the petition as amended?
Yes, ma'am.
Ms. Marsh, same question?
Yes, ma'am.
Okay. And I'd ask Ms. Gibson if you'd rename Ms. Marsh, please, so that the record shows accurate names?
Yes, Your Honor.
Thank you.
Sorry.
All right. If you admit the allegations in this petition today, you'll be giving a number of rights. The first is the right to a trial by a judge or jury. The right to require the prosecutor prove each of the allegations by a preponderance or majority of the evidence. The right to question the prosecutor's witnesses under oath. The right to have the court order that witnesses you believe could be helpful to you come to court to testify in person. Do you have any questions about these rights?
No.
Ma'am.
Do you understand the rights that you'll be giving up or losing if you enter a plea today?
Yes, ma'am.
Yes.
All right. There are a number of consequences that possibly may flow from your pleas today. The first is that your children may be made temporary wards of the court, which means the court has broad discretion regarding their placement, which can be in foster care with a relative or in a suitable institution. You'll be required to comply with a treatment plan to show you that you're able to provide a safe and appropriate home for your children. You may be required to pay for some of the costs of this case, including your attorney's fees, costs of care if children are placed outside of the home, counseling costs, etc. Now, we all hope that this next thing will not happen, and it's certainly not going to happen today, but I am required to tell you about all of the possible future consequences of your plea. If you cannot show that you can provide a safe and appropriate home for your children within a reasonable amount of time, given the circumstances and your progress, there may be a future request to terminate your parental rights, and your plea today may be used as evidence in that proceeding. If your rights are ultimately terminated in the future, you would have no input into your children's medical treatment, education, discipline, or residence. You'll also have no right to parenting time with your children and no right to inherit from them or receive their earnings. If you have a child support obligation, it will continue until a court of competent jurisdiction modifies or terminates it, an order of adoption is entered, or the child is emancipated by operation of law. Do you understand all of these consequences, Ms. Marsh?
Yes.
Mr. Marsh?
Yes, Your Honor.
Do you have any questions regarding the consequences of today's plea if you choose to admit these allegations? Ms. Marsh?
No.
Mr. Marsh?
No, ma'am.
Okay. And have you reviewed the petition and plea agreement with your attorney? Ms. Marsh?
Yes.
Mr. Marsh?
Yes, ma'am.
And Ms. Marsh, do you need to speak with your attorney again before we go any further?
No.
Mr. Marsh, same question?
No, Your Honor.
All right. I will now read each paragraph of the petition and ask you whether you admit or deny the paragraph.
I have to get my dog out of the room real quick. I'm sorry. 1 second. Sorry about that. She was trying to play.
All right, you're all set?
Yep.
Okay. All right. Paragraph A reads, Danielle Marsh is the biological mother of R.M. Date of birth, April 20th, 2017. A.M., date of birth, May 6th, 2016. S.M., date of birth, December 28th, 2012. S.P., date of birth, July 15th, 2010. And S.P.T., date of birth, February 9th, 2009. Ms. Marsh?
Yeah.
You admit?
Yes, ma'am.
Okay.
Or yes, sir. Sorry.
All right. Paragraph B, Timothy Marsh is the legal father to RM, AM, and SM. There is a Kent County front of the court case. The case number is 2019-0479DS. Mr. Marsh is in arrears of $14,926.92. Mr. Marsh?
Yes, ma'am.
You can just say I admit.
I admit it, yeah.
Okay. All right. Paragraph C was stricken. Paragraph D reads, Scott Parks is the legal father of SP and SPT. There's a Kent County front of the court case. The case number is 2010-08136DS. Mr. Parks also signed an affidavit of parentage for SP. There's also an FOC order for her. The court number is 11-02034-DP. Mr. Parks is in arrears of $11,973.95. Ms. Marsh?
Yes, that's correct.
Okay, you admit that paragraph?
Yeah. Yeah, I
Okay.
admit it.
All right. Paragraph E reads, Danielle Marsh has placed SP in a power of attorney with her former neighbor, Hannah Balliet, in November 2024. SP has been residing with Ms. Balliet for several years. Ms. Marsh?
Yes, that's correct.
Both parents raise their right hands, promising to tell the truth as the judge lays out the rights they're giving up.
I agree with it.
You admit?
Yeah, I admit it. I'm sorry.
Yep. Okay. Paragraph F, SPT currently resides with her adult sister, Starlette Schrader, due to a criminal no contact order between SP and Danielle Marsh. Scott Parks did sign a power of attorney allowing SP to reside with Ms. Schrader.
I admit it.
All right. Paragraph G, Danielle Marsh, Timothy Marsh, and Scott Parks have the following CPS history involving their children. In September of 2007, a Category 2 for failure to protect and physical neglect. In June of 2008, a Category 3 for physical abuse and improper supervision by Ms. Marsh. In December of 2008, a Category 2 for improper supervision and physical neglect by Ms. Marsh. In July of 2020, a Category 2 for physical abuse, neglect, and improper supervision by Ms. Marsh.
I admit.
Hold on. And in June of 2025, a Category 3 for physical injury and threatened harm by Ms. Marsh.
I admit.
Okay. Mr. Marsh?
Admit it.
Okay. Paragraph H, Daniel Marsh has the following criminal history. A, on July 15th, 2021, pled guilty to a misdemeanor operating impaired. Paragraph B, or sub B, on August 14th, 2025, Ms. Marsh was arrested for misdemeanor assault, excluding sexual. Charges are still pending currently. Ms. Marsh?
The charges were resolved as of Monday, and I pled
Oh, okay.
guilty.
Hold on. This
Okay.
is the petition as at the time that it was
Oh,
written.
I
Okay,
admit.
so it's not as of today. It's as of the time this petition was written. So I'll ask again. Do you admit or deny?
I admit.
Okay, thank you. All right. Paragraph I. Timothy Marsh has the following criminal history. Sub A. On January 6, 2017, pled guilty to a misdemeanor for domestic violence. Sub B, on September 20th, 2021, pled guilty to a misdemeanor for assault and/or battery. Sub C, on January 6, 2022, pled guilty to a felony controlled substance possession of methamphetamines/ecstasy. Sub D, on November 10th, 2022, pled guilty to a misdemeanor controlled substance use, methamphetamine. Sub E, on October 1st, 2024, pled guilty to a felony police officer assaulting, resisting, obstructing, and misdemeanor controlled substance, methamphetamine. Mr. Marsh.
I admit it.
Okay. J, Scott Parks has the following criminal history. Sub A, on April 2nd, 1990, the prosecuting attorney charged Mr. Park with felony controlled substance delivery manufacturing. There is no data for the judicial segment. Sub B, on October 1st, 2010, pled guilty to a misdemeanor for domestic violence. And sub C, on December 19th, 2018, pled nolo contendere for felony assault with intent to do great bodily harm, less than murder or by strangulation. Ms. Marsh?
I admit.
Paragraph K, on May 14th, 2025, the Kent County Sheriff's Department Deputy Nicholas Williams and Sean Harp responded to a domestic assault in progress at Danielle Marsh's residence due to Ms. Marsh assaulting SPT. Ms. Marsh was arrested and lodged at the Kent County Correctional Facility. The report incident number is 25127138. This resulted in a criminal no contact order between Ms. Marsh and SPT. Ms.
I
Marsh?
admit. I admit.
All right. Paragraph L as amended on May 15th, 2025, Ms. Starlet Schrader stated that Danielle Marsh called her from jail and asked her to flush her drugs located in her nightstand. Ms. Marsh?
I admit.
Paragraphs M and N are deleted. Paragraph O, on June 5th, 2025, CPS worker Kate Polad interviewed Danielle Marsh. Ms. Marsh admitted to disciplining SPT due to SPT not doing well in school. Ms. Marsh admitted to only grabbing SPT by the arm. Ms. Marsh pled to domestic violence on August 27th, 2025.
I admit.
Paragraph P, on June 5th, 2025, Danielle Marsh denied currently using methamphetamine and cocaine to CPS worker Kate Polad. Ms. Marsh only admitted to trying cocaine and methamphetamine one time many years ago. Ms. Marsh refused to complete a drug screen for CPS worker Ms. Polad. Ms. Marsh?
I admit.
Paragraphs Q and R were stricken. Paragraph S was stricken. Paragraph T reads, on June 26, 2025, CPS ongoing worker Beth Martinez completed a drug screen with Danielle Marsh. Ms. Marsh admitted it would be positive for methamphetamine and THC. The drug result confirmed Ms. Marsh was positive for methamphetamine, 2037.1 nanograms per milliliter, and THC 2.1 nanograms per milliliter. Ms. Marsh?
I admit.
Paragraph U, on July 2nd, 2025, CPS ongoing worker Beth Martinez met with Timothy Marsh. Ms. Marsh attempted to drug screen Mr. Marsh. Mr. Marsh refused to drug screen, stating CPS can obtain his drug screen results from his probation officer. Mr. Marsh admitted that while he was on probation, he tested positive twice for methamphetamine within the past year. Mr. Marsh?
I agree. I admit it.
Okay. Paragraph V was stricken, VW and X are stricken, with a new paragraph V to read, Ms. Marsh participated in prevention services, however, would not sign a release of information to allow CPS to verify participation. Ms. Marsh?
I admit.
Paragraph Y was stricken. Paragraph Z, on October 15th, 2025, CPS ongoing worker Beth Martinez contacted Timothy Marsh's probation officer, Ryan Shields, to obtain his drug screen results. Ms. Martinez found out that Mr. Marsh is still on probation. Ms. Martinez was informed Mr. Marsh tested positive for methadone on August 12th, 2025, failed to test in June and July, and tested positive twice for methamphetamine in May. Mr. Marsh?
I admit it.
Okay. Paragraph AA, as amended. Timothy Marsh is unable to provide proper housing for the children at this time.
I admit it.
Okay. Paragraph BB, on August 15th, 2025, CPS ongoing worker Beth Martinez spoke with Timothy Marsh about completing a drug screen. Mr. Marsh would not comply with this request. Mr. Marsh said the positive methadone screen was a false positive. Mr. Marsh then told CPS worker Martinez to, quote, fuck off, end quote, and hung up the phone.
I admit
Mr.
it.
Marsh? Okay. Ms. Marsh, has anyone made any promises to you or threatened you in any way in order to encourage you to admit these allegations?
No, Your Honor.
Are you admitting these allegations of your own free will?
Yes, Your Honor.
Mr. Marsh, has anyone made any promises to you or threatened you in any way in order to encourage you to admit these allegations?
No, ma'am.
And are you admitting these allegations of your own free will?
Yes, ma'am.
Ms. Marsh, has anyone told you that the court would go easier on you if you admitted these allegations?
No, Your Honor.
Mr. Marsh, has anyone told you that the court would go easier on you if you admitted these allegations?
No, ma'am.
Okay. I'm satisfied that there's a factual basis to accept the pleas that have been entered by Mr. and Ms. Marsh. I'm satisfied that they have been fully advised of their rights and are freely, understandingly, and voluntarily entering into these pleas regarding the allegations of this petition. I further find by a preponderance of the evidence that one or more of the statutory grounds alleged in the petition are true, and that Danielle Marsh and Timothy Marsh are respondents in this matter. Appellate review is available to challenge any errors in the adjudicatory process, which may be challenged in an appeal from the initial order of disposition following adjudication. If you are indigent, you are entitled to the appointment of an attorney to represent you on any appeal as of right and to the preparation of any relevant transcripts. You may be barred from challenging the assumption of jurisdiction or removal of your children from your care and custody in an appeal from the order terminating parental rights if you did not timely file an appeal under MCR 7.204 or a delayed appeal under MCR 3.993C. At any time while the court retains jurisdiction over your children, you may challenge the continuing exercise of that jurisdiction by filing a motion for rehearing under MCL 712A.21 or by filing an application for leave to appeal with the Michigan Court of Appeals. And Ms. Clifton, do you and your adjudicative witnesses wish to be excused?
Yes, Ms. Martinez as well as Mr. Shields. Thank you.
All right. Any objection?
No objection.
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 All right. Thank you. You're excused.
Thank you.
Great. We will move on to disposition at this time. Ms. Colletti.
Thank you, and I would call Aaron Peters.
Catholic Charities, West Michigan.
And you were assigned the case of the Marsh Parks Thompson children.
That is correct.
And for today's hearing, then you prepared several reports.
That is correct.
Then I would, I'll name them all and move through admission at the same time. Exhibit 1 is the ISP with attached PATPs, one for each mother, father, and the children. Exhibit 2 is Danielle Marsh's forensic fluid test. And Exhibit 3 is Tim Marsh's forensic fluid test results.
The judge reads each allegation, and both parents admit one by one. Years of violence, neglect, and drugs spill into the open.
Any objections?
No objection. Objection.
They're admitted.
Thank you. Ms. Peters, you've prepared a PATP for mother.
Yes, I have.
Is she currently working on that PATP?
She is.
And you've identified her needs specifically as, I believe mostly it's substance use has to be addressed.
I would say substance abuse as well as emotional stability and parenting skills, as well as child characteristics and domestic relations.
And have you referred her for a psych eval?
I have. The funding has been requested.
Okay. And that has not occurred yet?
That is correct.
And Ms. Marsh is starting to work on this treatment plan?
She has started to, correct.
And you've made referrals for parenting classes?
Correct. She started parenting classes on the 7th of October.
And you also made referrals for counseling?
I have, I did not make the referral. She is currently seeing a therapist through the Family Outreach Center. And she has started services, I believe on July 24th was when she started.
And has she signed releases for you?
She has not signed a release, but she has provided verbal consent for me to speak with her. But I have spoken and hopefully we'll get a release signed later this week.
All right. So Ms. Marsh, I'm sorry, is taking this seriously and has basically hit the ground running, would you say?
In certain areas, I would say she has.
Okay, there's work to be done, but I mean, she's taking this seriously.
I would say so.
All right. And with regard to her parenting, 3 of the children don't want to see her. Is that correct?
That is correct.
And that's something that you'll continue to work with and assess?
That is correct.
And Riker recently did not want to, I'm sorry, RM recently did not want to attend a visit?
That is correct. RM denied his visit this week on Thursday due to the past 2 visits being canceled. RM was very disappointed and did not want to be disappointed again at this visit.
All right. Are you asking then that you be your discretion whether to allow visitation or not? Or are you asking that DM get to the agency in advance so that RM doesn't make the trip down and be disappointed?
I guess I'm not too positive. I would say the visits, I mean, they have been moved to the agency due to a prior incident. I would say if he would be able to make it there in advance, that would be helpful, but I'm not too positive.
Okay, so are you then asking the court to leave in your discretion if RM does not want to have parenting time, that he not be forced to go?
That is correct.
Okay. Anything else as it relates to mother?
Yes, during one of the most recent parenting time visits, I had canceled the visit as per our policy. Miss Marsh had not shown up within 15 minutes. Miss Marsh had then continued to call me on the phone and started to scream at me using heavy profanity, probably every couple words. I tried to de-escalate Miss Marsh and explain the situation, and she would not let me speak. She continued to use extensive profanity, and before she hung up the phone, she made a statement. Pardon my language, she said, "I'm gonna kill that fucking bitch," and then she had hung up the phone. And so due to that, there's been a safety plan in place, as well as visits will be moved to our agency.
Okay, that's why visits were moved, correct?
Correct.
Now, with regard to the threat to you, were you forced to per policy to file a police report?
I did file a police report.
And do you know the result of that investigation yet?
I do not.
And do you feel comfortable continuing to be the foster care caseworker for this case with your relationship with Ms. Marsh?
With our safety plan in place, I do feel comfortable. I have minimized contact and I'm not able to be with Ms. Marsh unsupervised.
All right. And your supervisor is in support of that safety plan?
To my knowledge, yes.
All right. Anything else now as it relates to Ms. Marsh?
At this time, Ms. Marsh has, we have also had her do forensic fluid drug screenings. The most 3 have been positive for methamphetamine. She reports that she is attending AA classes, but has not signed a release form for those as well. If I do not get a release form for those, I will be referring her to Arbor Circle substance use classes.
Do you think substance use classes would be sufficient, or do you think she might need IOP, or you're going to send her for substance use assessment?
I feel that substance use classes would be beneficial, and then we will continue to monitor, and if further assessment is necessary, we can get that in as well.
All right, so that's something you'll continue to evaluate and make recommendations based on her needs?
That is correct.
All right. And the goal remains reunification?
That is correct.
All right. Moving on to Mr. Maresh, he's currently incarcerated?
That is correct.
Is he able to work a treatment plan?
Yes, he is.
And has he started working that treatment plan?
He has. He has reported to be in a sober living union program while incarcerated, and other areas will continue to be addressed upon his release.
Okay, and you identified his needs in the parenting treatment plan?
Yes, I have.
What is primarily, what is he addressing?
Parenting skills, substance abuse, and domestic relations, as well as child characteristics.
Does he have a relationship with his children or a bond?
He does, to my knowledge, yes.
Okay, and so when he's released, then parenting time would be appropriate at the agency supervised?
That is correct.
And you're expecting him to also undergo drug screens?
Yes, that is correct.
And you'll make the referrals then for counseling?
Yes.
And for whatever substance use treatment he needs?
That is correct.
And will you refer him for psych eval as well?
Yes, I will.
All right. Anything else for Mr. Marsh?
No.
Okay. There are 5 children here. The 2 older are both placed in different places, and then the 3 youngest are with a grandmother, correct?
That is correct.
And the oldest, SP, is doing well she's with her sister?
That is correct. SPT is placed with her sister, doing very well. She does have a no contact order with Miss Marsh.
Okay. And she's attending school?
Yes, she is.
Health-wise, she's healthy?
Yes.
And have you made a referral for counseling for her?
She is currently in therapy services weekly as well as services through wraparound monthly.
Okay. And all her needs are being met?
Yes, we are looking to get her a follow-up dental appointment as she does need some dental work done. So we are working on finding a dental office that will take her insurance. But other than that, her needs are being met.
Okay. And SP is currently placed, I believe, with a friend?
SP is placed with a caregiver she has resided with for around 2 years. She's doing very well with that placement
Okay.
as well.
And I believe father had signed a power of attorney for this placement?
He signed a delegation of parental authority.
Okay. He does not have full custody, though, correct?
No, he does not.
Okay. So if we wanted to do a guardianship with either Ms. Balliet or Ms. Schrader, he would need to get legal custody, or mother would have to consent to guardianship, correct?
That is correct.
Is that a goal you're looking at
Yes,
due to the children's ages?
that is correct.
Okay. And as well as their wishes, correct?
Correct.
All right. I'm sorry, I didn't ask about SP's educationally. She's doing okay?
She's doing okay. SP is shy and more timid regarding school, but to my knowledge, her grades are high. I know she has used a friend for tutoring, which has helped improve her grades as well.
Right. Health-wise, any needs?
Not to my knowledge, no.
Okay. And is she getting counseling as well?
We are currently working on getting her enrolled with Network 180. We are just waiting on some consent forms to be signed, but then she will be all set.
Okay. And the 3 younger are placed with grandmother?
That is correct.
And SM is attending school?
That is correct.
Actually, all of the kids are attending school, correct?
Correct.
And how about their health? All the kids, are their health needs being met?
They are.
And are you making referrals for counseling for all 3 children?
Yes, we are working to get them all in counseling with Montcalm Care Network.
Okay. Anything else that the children need, or other needs being met by grandmother?
The caseworker describes the mother's progress, then reveals a disturbing twist. After missing a visit, the mother called her screaming and threatened to kill her.
They are being met by grandmother. Riker has struggled behaviorally the past few weeks due to the lack of visits with his mom. He has become more destructive and angry, threatening caregiver's lease. So I have submitted a referral for enhanced foster care. There is a wait list right now. His services with Montcalm Care Network were denied. So I'm also looking into other therapy options that we can get him enrolled in for additional support.
Okay. And at this point, AM and SM are refusing to see mother?
That is correct.
And that's something you'll continue to evaluate?
That is correct.
And you think that it's in their best interest to allow the agency to use their discretion and respect the children's choices?
Yes, that is correct.
Thank you. What are your recommendations?
It is respectfully recommended that Skylar and SPT remain temporary court wards in a relative placement or with an approved caregiver. It is respectfully recommended that SM, AM, and RM also remain temporary court wards in an out-of-home placement. Ms. Marsh and Mr. Marsh comply with and benefit from their parent agency treatment plans. Ms. Marsh and Mr. Marsh's parenting times be supervised at the discretion of the agency, and that a review hearing is held in 90 days.
Thank you. I have no other questions.
Thank you. Ms. Newhouse.
Thank you. So how long in duration are the parenting times set for? Is it 1 time a week for so many hours?
Parenting time is once a week, and it is an hour long.
Okay. is there an availability to extend that a little bit so that Ms. Marsh can have a more meaningful visit than just an hour?
It is challenging due to the children's school schedule. They need to go to bed at 8 p.m. as they wake up for school at 5 a.m., as well as the visits having to be supervised at the agency. That is around an hour away from the caregivers, like their placement. So that would impact their nightly routine if the visits were extended. As well as mom works until 5 p.m., so she is not able to get over here sooner.
Is she allowed telephone calls?
At this time, no.
Why? Why not?
Due to the visits still needing supervision, we have been unable to coordinate a time that we can have an agency worker present for those phone calls. And at this time, the caregiver is not willing to supervise those phone calls.
And then this incident just recently, I guess, where RM said he didn't want to attend the visit. Was that told to you through another person, or did you speak with RM directly?
We spoke with RM directly over the phone.
Okay. Let's see. Have you been to Ms. Marsh's house?
I have.
Okay. Is it appropriate?
It is appropriate. There's not enough rooms for all 5 of the children, or even all 3 of the children. But everything else is appropriate.
Okay. So she has a lower level, right?
She does.
Okay. So it would be appropriate for when this petition was brought, I think RM and AM were living there. Is that right?
To my knowledge, it was only RM that was living with her, but I'm not positive.
Okay. And let's see, Ms. Marsh works, correct?
That is correct.
Have you done a budget with her or anything like that?
I have.
Okay. And it appears from the petition she wasn't getting any assistance from either of the fathers for the children, correct?
Correct.
So she was supporting the children the best she could?
That is correct.
Okay. And let's see, she also began divorce proceedings because she's still legally married to Timothy Marsh, correct?
Correct.
And that's positive?
I'm unsure.
Okay. And have you talked to Ms. Marsh about the possibility of consenting to a guardianship for gotta get these names right, SP?
I have not yet, but I will.
Okay. And the 3 younger children were placed with their paternal grandmother, correct?
Correct.
Are you aware that Riker is allergic to smoke?
Yes, I'm aware of that.
Are you aware that the paternal grandmother smokes?
I am aware of that, yes.
Have you, is he exposed to cigarette smoke in the home and in the car?
I'm unsure about the car. I know we do have a safety plan put in place with the caregiver regarding substance use in the home. And she is not to use substances inside as well as around the kids.
Well, when you say substances, she also smokes marijuana, correct?
I am unsure.
Okay, so the safety plan says no smoking marijuana. When you say substances or any type of smoking, cigarettes, I don't know, what does it say?
I'm not positive. Our licensing team had written up the safety plan. It was not me personally. I believe it was any marijuana or any other substances that she could smoke it. I'm not too positive off the top of my head.
Okay, but you're going to check into that, especially because you know he's allergic to smoke, right?
Correct, yes.
And then were you aware, this was told to me, I don't know if it's true or not, but the paternal grandmother allowed the 2 girls that came out of the camper to have another night at that camper since she got custody or placement?
I was just recently made aware of this. I am in the process of also writing a safety plan regarding this as well.
That camper had no heat or water, correct?
I am unsure.
Okay, and is that camper on premises of a house that has a sexual offender in the home?
That is what was reported, but I am not sure if that was confirmed.
Okay, so you need to, I would imagine, follow up on that too. They shouldn't have contact with that home if that is indeed true.
That is correct, yes. And I will be following up with all of the kids this week, as well as the caregiver, regarding that complaint.
Okay, so you've got how many kids here? Five, six, kids, 5 kids, right?
5 kids.
And then we've got 3 different placements. Is that right?
That is correct.
Are you familiar with CASA and the services they provide?
I am familiar.
Would that be helpful for you, given that we've got children placed out of county, and I don't know if that's too difficult for CASA, but would that help you, assist you in any way, if you know?
I would say it could be helpful as a support to them.
Okay. Thank you. Nothing further.
Thank you, Ms. Ortega.
Thank you, Your Honor. For Mr. Marsh, is there anything else that you would like him to complete or do while he is in the jail?
While he is in jail, at this time, no. We just ask that once he is released, he will follow the parent agency treatment plan as well as our recommendations. As well as once he is released, he will contact me directly.
Okay, do you need him to sign any releases as he's in a sober living unit? Do you know if he's getting any counseling while he's there?
I'm unsure.
Okay, is that something you can follow up with him about?
Yes.
No further questions, Your Honor.
Ms. McClure, do you have any questions? Your client's not a respondent, but
Yeah, I do just have one question. Can you tell us whether there are sibling visits being arranged between the children that aren't living together?
There are sibling visits, at least monthly. They all see each other as well as they remain in frequent contact over the phone.
Okay, thank you.
The agency details how the children are holding up, some refusing visits, one becoming violent, all scarred by the chaos they've lived through.
Ms. Coletti, any follow-up?
No, thank you, Your Honor. And no other witnesses.
Okay. Ms. Newhouse, any follow-up questions or any additional witnesses?
No, Your Honor.
Ms. Ortega?
No, Your Honor, thank you.
All right. Statements. Ms.
Thank you, Your
Coletti.
Honor. I did have an opportunity to visit with the children. I support the placements and the recommendations made for them today. I think that they remain in the best interest. I would respectfully request that you allow the agency to allow visitation at their discretion. If the children choose not to visit, then I think that their wishes should be respected at this time. And I think mother seems to, other than making a threat, which I don't approve of, I think that she is addressing issues that are contained in the parent agency treatment plan. So I would just ask that you adopt the recommendations. I think when father gets out, I'd like to see him get involved as well. So if you would adopt the recommendations and set this for 90 days. Thank you.
Okay, thank you. Ms. Newhouse.
Thank you. First of all, Your Honor, I would respectfully ask the court to waive court fees for my client, Ms. Marsh. She is working services, working really hard. She's trying to get to appointments and work at the same time. And as the petition showed, $26,000 in arrears from the fathers has not helped her. And she has maintained a home, and the imposition of court fees could jeopardize her ability to keep that home and be able to provide for her children when they return home and are reunified. She has concerns about the placement of the 3 youngest children with the paternal grandmother. Riker's allergies are a big concern for her. She's very concerned about him being exposed to smoke. And I would hope that the agency follows up on that, not just smoke in the home, but in the car, anywhere where he's enclosed or subjected to that smoke, is could jeopardize his health. My client is working on her therapy. She has been dropping. She wanted the court to know that she is working on taking accountability for this case coming to the court today. And she loves her children. She would like to provide for any and all of them. At this point, she does feel that the guardianship would be appropriate for the one daughter. But she's willing to discuss that with the agency. She's participating in her recovery program. She's been doing services with Families First since July. So we have a ways to go. We understand that. She wants the court to know that she and especially the youngest child, RM, are very bonded and very attached. And she would also ask that the court enter a dual order, not that we have to use it, but a dual order that should her screens be negative and she's making progress in her therapy and services, that the child or children could go home to her in the next reporting period if she's making substantial progress. Thank you.
Thank you. Ms. Ortega.
Thank you, Your Honor. My client is supportive of the recommendations. He is in the sober living unit and understands that sobriety is one of his main issues. He's able to work in housing. It's my understanding that he will have employment when he is released, and that he's in right now just serving out the rest of his probation. His probation was revoked for the violation, drug use. But so when he is released, he should have no pending charges, no issues there. And so I would also ask if the court, I think at the stage after adjudication, to have ancillary services approved. It has to come by court order at this point. They are still legally married, Mr. and Mrs. Marsh, but they have not been together for quite some time, and I think just have not finalized that. So my client would like to pursue that, and I'm happy to serve on that if the court would order ancillary services for him, and I can help get him through that portion as well. Thank you.
Thank you. All right.
Your Honor, I know my client is not a respondent, but I did have a question.
Sure, go ahead.
Katie Johnson is his appointed attorney. I'm covering for her today, and she informed me that she had previously discussed a request for ancillary services for Mr. Parks as well. And she told me that she would be willing to be appointed to represent him in that. And that's something that she had discussed with the prosecutor's office previously, and they supported.
Okay. All right. All right. The court finds that the lawyer guardian ad litem has complied with the requirements of the statute. Returning any of these children to a parent today would cause a substantial risk of harm to that juvenile or society. That consistent with circumstances, reasonable efforts to prevent or eliminate the need for removal of the children from the home were made as determined as a prior order. That reasonable efforts should be made or shall be made to preserve, reunify the family, make it possible for these children to safely return home. The custody of the children with a parent, presents a substantial risk of harm to the children's life, physical health, or mental well-being. No provision of service or other arrangements except removal is reasonably available to adequately safeguard the children from the risk of harm to their life, physical health, or mental well-being. Conditions of custody, the placements away from the home and with the individuals with whom the children are placed are adequate to safeguard each of them, each of their health and welfare. These siblings are in joint placement. It is ordered that the children are placed in the temporary custody court, placed with the Department for Care and Supervision. That the adjudicated respondents, Mr. and Ms. Marsh, comply with and benefit from the case servants plan, including signing any necessary releases. That parenting time with Ms. Marsh is at the discretion of the agency to allow unsupervised or supervised parenting time by its designee. Parenting time of Mr. Marsh is supervised until further order of the court. The court waives court costs for Ms. Marsh. Does order that Mr. Marsh pay court costs. I will appoint a CASA for these children, and we'll probably have multiple CASAs, but I will leave that up to the discretion of the program. Parenting time is at the discretion of the agency in terms of determining if there's an individual child that does not wish to visit. The court leaves it in their hands in addressing that therapeutically and encouraging that child to visit, but not forcing the issue at this point. We're at the very beginning of this case. And the court will approve ancillary services for Mr. Marsh and Mr. Parks. And Ms. Gibson, do we have, oh, and I let me switch back here. The court also finds that reasonable efforts have been made to finalize the court-approved permanency plan of return to a parent for the 3 younger children. And Ms. Gibson, do we have a date for our next hearing?
Yes, Your Honor, January 6th from 11 to 12.
January.
Any conflicts with that date or time?
That works for me. Thank you. 11 to 12.
All right, and I did not, I am not ordering a dual order at this time. This is, as I said, this is the very beginning of the case, and I really want, I wish Ms. Marsh, I wish you the best of luck in terms of achieving sobriety, but it's going to take more than a couple of months. The court really needs to see 6 months of sobriety when you have a substance abuse issue as severe as yours before we can look at reunification. So it's hard. We all know it's hard, but you'll get there. And 6 months is not as long as it feels like right now. But you do need to really work hard on this. All right. And is there anything further?
The judge gives her ruling with firm compassion, telling the mother she needs 6 full months of sobriety before any chance of reunification. You can almost hear her voice crack as she wishes her luck, reminding her that hard work, not words, will bring her children back. The gavel falls, closing one chapter and leaving everyone in silence. Don't forget to like the video, subscribe to the channel, and we'll see you in the next one.